Impact of Influence.
Covering true crime throughout the Southeast.
Hello, friend. In this episode, you will find out who says Becky Hill's comments during the Murdaugh trial were just fleeting and foolish. Hey, it's Matt Harris, Seton Tucker, and we are always grateful you to spend time with us. And how can they join in the convo?
You can find us on Facebook at Impact of Influence and also on our YouTube channel.
And if you get to the YouTube channel, hit that subscribe button. Very important for us to keep doing what we're doing. And hopefully you're enjoying it. And support our sponsors to help us too. Quince and Mint Mobile come to mind, part of the Evergreen podcast company. Well, Seton, more Murdaugh, and it has taken a while to get to this point. In fact, it was like the last second before the state responded.
Yeah, so the state filed their brief shortly before midnight on the deadline of August 8th. Like, talk about last minute.
Yep.
That's exactly what we tell our kids not to do. What if you have some sort of computer difficulty? I don't know.
I don't know if there was a strategy. Maybe someone can fill us in on that. Or was it truly a computer problem? Was it, let's just make sure we go over every single T and I and make sure they're crossed and dotted?
Maybe they were working till midnight.
Yeah. The state's brief is big. 182 pages. That's nearly 3 times the normal length of a response brief. And the state had filed a motion because you have to say it's going to go past our limit. And they did that. And as of this recording, the brief's still not available in the South Carolina Public Index. Not really sure why. Maybe because it can't hold 182 pages.
I know. It might be too long.
But thank you, Fitz News, because they had posted it and we got it from there to read.
Now, after reading, I thought it was a very strong filing by the state. In my non-legal opinion, the financial crime motive actually made sense to me for the first time.
You thinking it made more sense to you in this, when they wrote it?
In this filing than it did when I watched the hearing. They really did connect the dots. I still have some questions about what they say is an overwhelming amount of evidence indicating guilt, not arguing that. But does that matter in the legal context? The biggest issues that I see are the tampering by former Clerk of Court, Becky Hill, and also whether the financial crimes were improperly admitted to the extent that they were.
I watched Court TV. I don't know why Vinny didn't ask for my legal mind.
I know. I was kind of sad.
I'm going to call Vinny Politan. No, because they had attorneys on. And again, we don't know if they seem to decide with defense on this. All 3 of them were like, we don't care if the evidence was there or not. All 3 of them said there should be a new trial. And if one guy said, or maybe it was the woman, I'm not sure, said if there wasn't, that's setting a bad precedent, because now anytime somebody involved in the court, that was their biggest problem. It wasn't just a person. Vinny made a point. He said during the Karen Reed trial, they did everything they could to protect the jury from hearing from outside voices, like all the crowd and all that sort of stuff. But you can't protect from the people who are actually dealing with the jury. You can't, the Clerk of Court, the bailiffs, those kind of people. And so they should be doing what they're supposed to do. So that was their take.
That was their take. Now, I watched the segment. They played a clip of Justice Toll questioning Juror Z. Mm-hmm. And, the legal, talking heads on Vinny's show were saying that, it's not about this overwhelming amount of evidence. It was more about protecting the integrity of the system and setting a precedent. Right.
So we'll talk to one of the people who was on that little talk desk or whatever in another episode. But we'll break down some of this stuff right now. The state's brief details the pressure Alex Murdaugh was facing, although outward he appeared to be this very successful guy with this great family, loving father, loving family. But they have used this quote many times. They used it during the trial. They use it here, which is storm is gathering. This whole thing's brewing. The storm is a gathering. According to the brief, Alex Murdaugh's financial problems began in 2008-09. Following unsuccessful real estate ventures, which I found interesting.
Well, that's when the kind of real estate market tanked.
Right.
A lot of people got underwater with their houses or other real estate investments.
But I don't remember them talking about the real estate during the trial.
I don't remember this either. That's why when I'm reading this filing, I'm like, wow, they're really connecting the dots of how this motive makes sense to me.
And I know at one point, and I don't even know it was during the trial, I think it was just when they were asking them about where'd all the money went, and they were like, well, these real estate dealings. But I don't remember it being part of the trial.
It's possible I missed it. I don't know.
If it was quick. So they say Alec responded to his financial stressors by stealing from his clients and law firm. We know that's true. And he continued to do so on a routine basis for years, illicitly, illegally, taking millions that did not belong to him, on top of continuing to borrow heavily from Palmetto State Bank and other institutions while making a considerable legitimate income. He was over six figures, sometimes more, sometimes less. It was based on bonuses and that sort of thing. But so all that is true. We know that to be a fact.
Now, additionally, there was this looming civil case regarding the boat accident in which Mallory Beach was killed, and Paul was the alleged driver. Now, the Beach sought $10 million from Alex Murdaugh personally in the civil lawsuit.
Because it was his boat and some of the money or some of the beer.
Paul was the alleged driver.
Yeah.
And to make matters worse, Alex Murdaugh, his multi-million-dollar umbrella policy had been canceled after the payout following the death of Gloria Satterfield.
So insurance wasn't going to cover.
He didn't have an insurance policy.
Yes, he didn't have it. Yeah.
Now, compounding his troubles further, Jeannie Seckinger, the chief financial officer of Palmetto State Bank, had discovered an issue with some of the disbursement funds. And Alex Murdaugh had placed some attorney's fees into a fake account that he had created. I believe that was the Forge account.
Right.
And when asked about it, Alex Murdaugh claimed that he was trying to get money into Maggie's name due to the pending boat wreck litigation.
Right. And the brief refers to the discovery by Maggie of several bags of pills in Murdaugh's computer bag. After discovery, Paul had texted Alex that they needed to talk, and Maggie was conducting internet searches attempting to identify pills by their markings. Now, this was not like the day of or anything like this.
This was in May. It was in May.
It was a little bit before. I think they were at a USC baseball game or something, right around then.
I don't know exactly when.
But it wasn't
but she did discover these bags of pills.
Another aspect of what the state calls a gathering storm again relates to the discovery of Murdaugh's paralegal of an issue with some attorney's fees with a case Murdaugh was handling with an attorney from another law firm.
I believe this was Chris Wilson. Now, according to the filing, the Moselle estate was entirely in Maggie's name, and Maggie also had a 50% ownership in the Edisto Beach house. So this meant none of the equity of those properties could be utilized by Alex Murdaugh without Maggie's knowledge or involvement if she remained alive.
So they would take it from his personal account or whatever, but
that was kind of a light bulb moment for me.
I don't remember that being.
I don't remember this, but that's what I'm like. I'm reading this brief and it's so well outlined. I'm like, all of a sudden, these financial crimes really made sense to me for the first time. I'm like, wait a second, he could not, liquidate any of these properties without Maggie being involved. And
I'm going to maybe talk to a financial person because let's say he can't. He doesn't have the money. They assume 10 million. He doesn't have 10 million. He goes into bankruptcy. Is that the end of he's going to go to jail. Does he need that? That's, I don't know, but I really don't remember her name on that. They didn't.
I don't recall that, but that's not to say that it wasn't
because it's been a few years.
Yeah.
The state says that Murdaugh was caught in a tangled web of his own making. True. And did not have the money to quickly pay back in order to deal or prevent his misconduct from coming to light. So that's what they're saying. So if he could have pulled the money out, he might have been able to pay back the money and maybe avoid charges, I guess is what they're saying. Just as he was running out of options to keep his years and years of criminal financial misconduct hidden from exposure, Maggie and Paul brutally killed. So they really almost seemed like a better...
They connected the dots.
Yeah.
They really did connect the dots in a way that I did not think had been done in the trial, but... there was so much evidence presented. It was a 6-week trial, so it's possible that I missed some of these things, and I'm reading just one brief that just outlines and very succinctly what happened.
Right.
Next, we hear about the horrific natures of the killings of Maggie and Paul. They talk about the lack of stippling, which suggests that both were shot at close range, and neither one had defensive wounds. Mm-hmm. Now, the filing says that just moments before meaning Maggie and Paul, phones were locked for the last time ever during their lifetime. Maggie and Paul had been down at the kennels where they were murdered. and they were not alone. Contrary to what he would later claim, he meaning Alex Murdaugh, would later claim over and over again to investigators, family members, law partners, friends, and anyone who would listen, appellant Alex Murdaugh was down at the kennels that night too, along with Maggie and Paul in their final moments alive.
That was the big lie. If that video hadn't come out,
yeah, and
they couldn't put him there.
Doesn't seem like Alex Murdaugh maybe knew this was that big smoking gun video that was taken from Paul's phone. He was taking a video. His friend's dog, Rogan Gibson's dog, was staying at Moselle. He had some sort of injury, and Paul was taking a video. And in the background of the video, you can hear Alex's voice. This was, and Maggie's too. The chicken, is that a chicken or a guinea?
Yeah.
That video.
And that didn't even come out was it right about the trial, or was the trial already began when they got that out? It was close,
no,
right?
it came out, I think, shortly before the trial.
Very shortly.
But we didn't know about it until the trial.
Right. Yeah, exactly right. That was the one that allowed them to place him there. And without that, I think would have been a harder sell.
Absolutely.
I'm not saying it wouldn't have sold, but it would have been harder.
Right.
The filing points out that despite Murdaugh calling Maggie 3 times in the span of just a few minutes without an answer, Murdaugh began driving toward his parents' house at Alameda without making a quick stop to check on the kennels in the way.
Right. So, he called her 3 times. She's not answering. They have 2 driveways in and out of Moselle. Why not just drive that way and say, hey, headed to Alameda?
Yeah. I mean, I don't think that was as big a deal as they said, but additional evidence that was presented at trial is mentioned, but it's real, like we said, 100 pages.
Long filing.
A 6-week trial, so lots of pages about it. Not possible to cover everything in this one episode, but what they were getting at was to tell the Supreme Court of South Carolina, look how much evidence there was pointing to his guilt. Does it really matter about this comment?
They use the word overwhelming.
Amount. Like, they're basically saying nothing anyone could have said would have changed these jurors' mind. Yeah. So after that, all of the talk about what happened in the 6-week trial, the filing says that what happened after the murders.
They said that everyone rallied around Alex Murdaugh to provide him support in the wake of the murders. The inquiries into the missing fees were halted, and the hearing on the boating case was postponed. And it also says, which I don't remember this from the hearing too, but I found this really interesting. It kind of connected the dots for me as well. Alex Murdaugh took advantage of the time he had in the weeks following the murders to secure funds and pay back a large portion of the fees he had stolen. However, ultimately, we know he was discovered. The theft was discovered and he was forced to resign, but he did receive a couple of loans. I think he got a loan from Johnny Parker and his dad. So he was able to kind of manipulate some of these funds in the aftermath of the murders.
Although none of the payback of that would have prevented him from being busted. I mean, maybe he would have claimed, hey, I was going to start paying people back.
Well, he had been getting away with it since 2008.
And he still got convicted. I mean, he's still in jail probably for life because of it. Moving on to the arguments, 2 biggest, we think, are going to be the alleged jury tampering by Becky Hill and the admission of financial crimes. The first arguments presented in the state's brief is that the jury convicted Murdaugh because he was, quote, obviously guilty, and not because 3 jurors heard Becky Hill's, quote again, foolish and fleeting comments about his upcoming testimony.
Okay, so we had 38 pages in the brief before we got to this argument. And the state really, outlined their case well. Was this to kind of say, hey, look at this case. It's a slam dunk. Mm-hmm. Also, and the other argument is going to be the financial crimes. And they really outlined how they think the financial crimes fit into this case. And
I'm going to wonder when we talk to an attorney about, does that matter when you're talking about whether some legal thing went wrong or there's jury tampering? Does any of that matter? Their cases, nothing could have changed anybody's mind. It wasn't a technicality or whatever Becky Hill said. It was just this amazing amount of evidence we had.
Right, but the state's position is that Hill's improper comments did not affect the outcome of the case.
Yeah, no matter what she said, wouldn't have changed anybody's minds.
Right. So again, the state is admitting that Hill made these improper comments. However, they say that the record supports Toll's finding that the verdict was solely the product of the jury's honest deliberations, and they reflect the overwhelming evidence of Alex Murdaugh's guilt.
And I think this is the first time we've really heard them kind of admit that Becky Hill's comments were fleeting and foolish. They said astonishingly inappropriate.
Yeah, astonishingly. They use the term astonishingly inappropriate in their brief.
And up till now, I mean, a lot of times they've been defending her in at least a little bit. But now they're like, yeah, it was awful what she said, but it doesn't matter.
But it's hard to say, like, did these, and again, I want to talk to a lawyer about this, because did these comments, how can we really tell if they impacted people's or the jurors' minds?
Right. We get affected by advertising and little comments throughout the course of the day, and we don't know, it didn't affect me. I still bought that kind of car, that cereal, or whatever.
It's definitely hard to tell.
Yeah. The state says during the post-trial hearing, Justice Toll was able to access the character and intelligence of the jurors and Hill. Justice Toll conducted an examination of the jurors who participated in deliberations.
Not the ag juror. No,
Nope,
she was not included in this.
Because she was kicked off the actual juror.
Right.
Jury.
And, you know, I guess one reasoning, you know, we've questioned why did they not hear from the ag juror during Toll's hearing, but we did hear from the alternate juror. But I guess in this brief, they kind of say, well, she was dismissed for legitimate reasons, you know,
she wasn't in the room
by Newman.
Yeah. As I said, Toll conducted an examination of the jurors, participated in deliberation. She modeled her inquiry after the South Carolina case, State versus Green, which we've talked about and we'll get into more in a little bit, and asked, was that an accurate statement about your verdict?
Four questions.
Yeah, these are the four basic questions that all the jurors got. Was that an accurate statement about your verdict at the time? Was your verdict based entirely on the testimony, evidence, and law presented to you in this case? Did you hear Becky Hill, the clerk of court for Colleton County, make any comment about this case before the verdict? Was your verdict on March 2nd, 2023 influenced in any way by the communications by the clerk of court, Becky Hill, in this case?
Yeah, I think it's important that we should listen to Toll's examination of Jersey, because I think a lot of these arguments boil down to Jersey.
Let's hear it.
Did you hear Ms. Becky Hill make any comment about this case before your verdict?
Yes, ma'am.
If yes, what did Ms. Hill say?
To watch his actions.
To watch his actions? What else?
To watch him closely.
To watch him closely. Anything else you remember?
There it is, but I can't remember.
Okay, fine. Was your verdict on March the 2nd, 2023 in any way influenced in any way with any communications by the clerk of court, Becky Hill, in this case?
Yes, ma'am. Yes, please.
All right. Was your verdict influenced in any way by the communications of the clerk of court in this case?
Yes, ma'am.
And how was it influenced?
To me, it felt like she made it seem like he was already guilty.
All right. And I understand that. That's the tenor of the remarks she made. Did that affect your finding of guilty in this case?
Yes, ma'am.
I think we both agree that we were watching it in the courtroom, that Jersey was, I I don't want to say overwhelmed necessarily, but certainly.
I could say I would have been overwhelmed.
Yes.
I mean, it was a packed courtroom, standing room only. You're up on a podium being questioned by a former South Carolina Supreme Court justice with cameras in front of you.
Yes, and because she wasn't very loud, and it was a lot.
It was a lot, and
Yeah.
I don't know, if she has any sort of background of being up in front of people, or what. If she's from a small town, Walterboro is not very big. I don't know. I would have been very intimidated personally.
Right. So I think some of the confusion about her testimony and saying that she wasn't credible was to the fact that I think she was kind of confused by the open-ended questions that Toll gave.
She kind of blanked. Toll was asking her what she remembered, and she said she remembers saying watch his body language or something to that effect. But she does not say that she recalls hearing Hill say, "Don't be fooled," which I think "don't be fooled," watch his body language are two pretty different things.
And her attorney during the lunch break had asked or sent a note to Justice Toll saying, can she come back and kind of clarify things?
And she's asked if she felt pressure by other jurors during the deliberation process, and she says yes, which that's part of the normal jury deliberation process. But I think that, what confused me a little bit is you can feel pressure. She could have felt pressure, but she could have also been influenced by Hill's comments. Both of those things can be true.
The state says to cause prejudice, in other words, what Hill said affected them, and proper communications must actually affect the jury's deliberations.
Now, the state argues that Toll applied the right standard by using the Green case, which is a South Carolina case, that says that these communications do not automatically presume prejudice. Now, my understanding is that if Toll had relied on the federal case, the Rimmer case, Hill's comments to jurors would have been presumed prejudicial. Now, just that statement alone would not necessarily have been enough to warrant a new trial. However, and some of the case law that they present is very legal, chips away at Rimmer and how it's applied in different circuits, and that maybe it's not always presumptively prejudicial. I don't know. We'll just have to see how it plays out.
Right. The shifting of the burden of proof is what happens if it's Rimmer or Green, right? So if it goes to Rimmer, the shifting of the burden of proof goes from Murdaugh, the appellant, and that would seem to help them.
Right, because then it would be on the state.
The state would have to show that there was not anything said that impacted the outcome before Murdaugh had to prove that it affected them.
Right.
And they have now, so it just changes a little bit, and it'll play out. I'm not exactly sure how.
Now, however, the state argues that even if the presumption of prejudice is applied, like the Rimmer standard, the state rebutted it. They said that the ultimate question is whether Hill's improper communications influenced the verdict.
They basically say that the same outcome, whether it would have been Rimmer or Green.
Right, and those 4 questions that she asked basically proved that the outcome would have been the same.
And you had mentioned something about how it's a year out that they had the evidentiary hearing.
Right. It was quite some time, and the state does point out in their filing that, since the time of the hearing, that the jury would have been subject to different opinions and media and outside information that would possibly change their mind now versus what the verdict they rendered then.
So they want them to the jurors, you have to get inside your head what you were thinking a year ago.
Right.
Yeah.
And I think that's why, I do think that is why Toll really limited her questions, because, they could have seen things. We know they were watching from the jury room what was happening. So
I'm not in the Murdaugh trial, but in the evidentiary hearing.
In the evidentiary hearing, they could have seen things. They probably went online, or maybe they listened to our podcast or other podcasts.
Yes,
Who knows?
I hope so. No. So the state says 11. This is the quote: 11 jurors testified Hill's comments had no effect on their verdict. That's the big quote. So the verdict was reached in approximately 3 hours. It was a 6-week trial. So the state says, hey, look how little bit of time it took them.
Right.
The case is overwhelming. And given the strength of their case, they say it's not reasonable to include Hill's comments to any effect on the deliberations. The state says the record supports Toll's finding that the jurors took their responsibilities seriously and stood by their oaths to be impartial.
Now, the state says that Toll found that Juror Z's testimony, that her testifying that she said not to be fooled did not happen.
Right.
And when asked these open-ended questions, Juror Z said, watch his actions, watch him closely. They say that Toll's opinion of Juror Z's testimony was based on her own personal observations of Juror Z and other witnesses' demeanors, and she did not believe.
Toll didn't, yeah.
Yeah, Toll didn't necessarily believe her.
And that it's up to the judge in that case to do it. She happened to be a justice. The fact they call it what is it called, finder of the fact.
She is the finder of the fact. I mean, she was so it was her place to assess the credibility of.
She's like a jury
of the jurors that she polled and the witnesses they heard from Hill. She said she didn't necessarily find her credible. They heard from Rhonda McElveen, the other clerk of court who was assisting her. So she was the person who was going to look at all the testimony that she saw, and she was the finder of fact.
So she gets to rule.
Yeah. So I do think that is going to be a huge obstacle for the appellant,
For the defense.
The defense, because
It's Justice Toll.
it's
She was
Justice
a Supreme Court
Toll.
justice.
She's the one who was tasked with as the fact finder.
And it's going to be hard to convince a Supreme Court that a well-respected person didn't do or was mistaken.
Yes.
Right?
The state says in their filing that Toll's credibility determinations are final.
So there you go. All right. Next, the brief moves to the admission of the financial crimes. The state argues financial evidence was omitted for the purpose of establishing a motive. And it's not, quote, implausible and unsupported by the evidence as contended by the appellant. And according to the filing, the defense advanced other motives and theories for the killers.
The filing says that the trial judge, Newman, admitted the financial crimes on two different grounds.
Okay.
One, Newman found that the evidence of Alex Murdaugh's dire financial situation, coupled with the looming threat of his financial crimes being exposed, was clearly and convincingly established, reflecting his desperation at the time of the murders and constituted relevant evidence as a potential motive.
Right.
The second reason that Judge Newman found was the looming exposure of the appellant's financial crimes, along with the fact that the appellant sought to tie the killer's motive to the boat wreck, provided the necessary logical nexus between the bad act evidence and the murders. It's a lot of legal.
Right.
But basically saying, yes, he's got to have, it was essential to the motive, and also that he was trying to use this boating accident as a motive.
Because the clock was ticking. It was a few days later they're supposed to have this court case. So Newman found the evidence of probative value was greater than not substantially outweighed by any potential proper prejudicial value it may have possessed. So basically, Judge Newman said that this financial stuff went to motive more than it went to character. So this was about motive, not about character.
Right. And I guess when determining whether bad acts can be put in, you have to determine what the probative value is versus what the prejudicial value is. And I think that's going to be argued by both sides. We'll have to see what sort of arguments both sides, because I don't know. I can see it going either way. But let's also, Judge Newman instructed the jurors. This is another thing, that he properly instructed the jurors, not to consider certain things. So let's read what he had to say.
So this is Newman's words to the jury. Ladies and gentlemen, evidence or testimony is about to be offered that the defendant may have been involved in other criminal activities, and that evidence is not evidence or proof that he committed the offenses charged in the indictments. This testimony has been allowed and is being allowed for the limited purpose of assisting the state in providing motive. You may not consider this evidence for purpose of character of appellant Murdaugh, nor may you consider the evidence as evidence of his propensity to commit other crimes, or that it is more likely that he committed the crimes in which he is currently on trial. It is being allowed based on the state's representation that it helps explain the defendant's motive to commit the crimes for which he is accused.
I mean, I do think it does help explain the motive, which
Yes.
isn't necessarily required, but I think does make sense to try to explain why someone could do something this egregious. But I don't know, is it possible to separate in your mind after hearing these things? I don't know.
You have to hope that they follow the instructions because they are allowed to present motive, and you hope that they can separate.
And it's not like we heard that he was a wife batterer. I mean, we heard that he committed financial crimes. So there's a big difference between, he was, beating up his wife, or he had previously killed somebody else,
right.
or nothing. It wasn't these weren't violent crimes, but I still think, we were told about what a big liar he was, and then he got on the stand and we were expected to believe him.
That was where
was
really,
a little bit
yeah.
weird. The state also raises a procedural error in Murdaugh's appeal. They say that the trial judge admitted these financial crimes based on 404B and Rule 403, and that's not why he admitted them. So based on that, they say that they waived their right to an appeal on the financial crimes.
At least on that part, yes.
On that part.
The state presents lots of case law. They say support the positions that financial crimes were properly admitted. They say without the evidence, the jury would have been left with no way to truly understand the Murdaugh state of mind and dire circumstances at the time of the crimes. Again, we've said this a bunch of times. We need to say it again. Motive not required.
Yeah.
To find a guilty verdict, but when you have something, I think, where somebody's killing their wife and their son,
and there's they're presenting evidence that they, videos of them at a birthday celebration together appearing happy. So yeah, I see it. Or
the video right that day when he's out with Paul and he's messing around with the trees and stuff like that.
Right.
They're laughing and carrying on. You want to have a motive.
Yes. Now, the state also points out that much of the information presented was backed up by Murdaugh's own admissions when he took the stand.
That would be that he was at the kennel.
No. Well, I think also that he admitted to the financial crimes on the stand.
Yeah.
He admitted the financial crimes on the stand.
Yeah.
Let's get to this door opening situation.
Yeah. The state also responds to the contention that the door was opened to the admission of financial crimes by the defense's cross-examination of Will Loving. Defense counsel posed questions about what appeared to be a loving, quote, awesome relationship Murdaugh shared with Paul and Maggie. So when Griffin is asking...
It was a cross, yes.
Yes.
He's asking these questions, and the judge considered the responses elicited as character evidence, and thus opening the door and allowing the state to ask questions about the financial crimes. They're saying that, if the defense is presenting character evidence, in this case, good character evidence, that they're allowed to also present bad character evidence, which would relate to these financial crimes.
I see that seems pretty... clear cut.
Yeah, the state says Newman made the right call.
I'm not an attorney, but it sure seems like that's the right call in this case. And I've talked to a few attorneys who believe the same thing. We heard that Financial Week, as we mentioned, but the state contends the defense failed to state a legal basis for the objection. Explain a little more there.
Also, the state contends that the defense failed to state a legal basis for their objection. So what happened was Will Loving was on the stand, and the state asked him a question about his knowledge about some missing attorney's fees, I think like $792,000 of missing fees. And Jim Griffin objected, and he said totally improper. Well, the state is saying that is not really a legal basis, totally improper.
Because he didn't say, I object.
He object on hearsay or any sort of reasoning. But, so we'll see what happens with that.
There are a couple of other issues on appeal addressed by the state, questions that were asked to Murdaugh on cross. The iPhone expert, which right as soon as that was happening, we were all like, what is that? Because the iPhone expert, he goes on and he said, well, I flipped the phone like 20 times when I was at my desk.
Well, and I mean, the biggest ones seem to be the financial crimes and the jury tampering. And I was seriously growing cross-eyed. This is honestly the longest episode this has taken me the most amount of time ever to write an episode and wrap my head around it. I did not get out of my pajamas until 5:30 yesterday because I was spending so much time.
And she usually doesn't get out till like 3:30. So that was
I mean, it was only a few hours later than I typically get out of my pajamas. So the the defense has filed, as we're recording this just today, a request for additional time, which was granted. They originally only had 10 days to respond. Now they have 30 days to respond. I think that would make it due on September 9th. They also requested some additional pages since the state's filing was so long. They were limited to 50 pages, but now they have 75 pages to respond to the state's brief.
So they went more. I wonder if there's so many pages, as we said, so many more than they were supposed to have. The state, they asked for more room, but I wonder if a lot of things they're writing, they're hoping gets out because you're kind of, if there is a retrial, say for whatever happens, all this is laid out right there in public
Honestly, reading this, they laid out their case. It made so much more sense to me reading this brief, and maybe because it was, not over the course of
condensed.
6 weeks. It was condensed. They really did a fantastic job tying the financial motives together, and just
reading it made more sense to me.
I completely agree. I mean, I do still have a few questions about Maggie's phone and a few other things, but I definitely thought the financial crimes made sense for the first time that they had not previously made sense to me.
Agreed.
We have not seen a filing about the evidence uncovered by Jen Wood.
Oh, the text.
The text that the defense said that they had not received. So maybe they're going to file something else. I don't think that is. I think they have to file something before that. Wouldn't be something that they respond to in the brief. The appellant.
Because nothing's been filed yet.
Because nothing has been filed yet. And again, nothing in those communications was necessarily
a smoking gun.
A smoking gun, yes.
So to speak, yeah.
But I'm surprised that we haven't seen anything yet.
But maybe they're going to put it as part of the response.
No, they can't.
Oh,
I don't think. I think they have to file something first.
Separate.
I think they would have to file something with the court saying that they didn't receive these, and that would be.
Okay. So maybe they found out they did receive it. Or maybe they're going to file something in these next 30 days.
Maybe.
That's
But it will
days.
not. My understanding is it
won't be the response, but I mean,
but
they might file it between then.
Yeah.
Right?
Maybe.
Yeah.
We'll see.
We'll see. There you go.
You're going to go cross-eyed after this.
Yeah, we'll take a nap. We are super grateful, always grateful you spend time with us that we've been doing for 4 years. It's crazy,
oh my
right?
gosh. No, it can't be that long.
Yeah, 2021, right?
Oh gosh.
So 4 years.
4 years.
Over 4. So again, Impact of Influence on Facebook. From there, you get over to the YouTube channel. Hit subscribe. Part of the Evergreen Podcast Company, Mint Mobile, Quince. Thank you for sponsoring us and support our sponsors. We'll talk soon, friend.